So you all want me to say 2 years, and I'm telling you right now, you all don't get to dictate or make an agreement. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you, and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
All right, off the record. I see here where you all put state recommends deferred adjudication for a period of 2 years. You all are not allowed to enter into an agreement on the length of probation. So if that's a deal breaker, then
We had an extensive conversation on that, Judge. We understand it's within the court's purview to set the term,
then it
although
needs
I
to be
think
removed.
we can still agree to whatever we want to agree to.
All right, so,
And then what I would say is it doesn't bind the court, but
well,
I wanted to have the ability to withdraw my plea if the court was not going to follow that.
well, no,
recommendation.
you all are not allowed to agree to the term. And it says the state recommends deferred adjudication for a period of 2 years. That shouldn't be here. If y'all want to put down here, this is where your recommendation for 2 years is, but not above the line. So if y'all are trying to bind the court to the length of probation, I'm not going to allow y'all to do that.
That was not the state's intention, Your Honor. Both parties understood that the court has the ability to, and to order however long of probation the court deems appropriate. However, I think defense's concern was that we just wanted it known that our intention was the state was recommending 2 years of
Yeah,
deferred
I mean,
adjudication.
For the court, it's there at the bottom of the line. And if you all want to argue and fight for 2 years on the record, you can, but placing it above the line is not appropriate for the court.
I understand, Judge. I'm not going to quarrel. I understand.
No.
I mean, I expected you to say something along those lines. However, my position was we wanted to be able to withdraw our plea if the court wasn't going to follow the agreement.
So you all want me to say 2 years, and I'm telling you right now, you all don't get to dictate or make an agreement to the length of his probation if I follow the plea. And I know that's not anyone's intention, but it just should not be above the line, because this is what's binding upon the
Well,
court.
this is the last thing I'll say about it, Judge, and because I'm not arguing with any of the things you're saying. The issue is if I make certain representations to my client that induce him to accept a plea agreement, I don't want the rug to be pulled out from under him because then he winds up with a 10-year probation instead of a 2-year probation. And so I didn't know any other way to address that other than in this fashion.
All right, so this is what I can tell you, sir. The state and the defense are not allowed to present the court and make it binding on the court that I were to give you a probation term of 2 years. They can argue for the length of probation time. They can argue for certain conditions. The only plea bargain agreement you're able to enter into as a binding contract with the state is whether or not they're in agreement to you having deferred. If they agree for you to have deferred, hypothetically, we can go off the record. Hypothetically, if they were to agree for you to have deferred, and then you come to me and I say, I'm not giving you deferred, I'm giving you a conviction, then I have not followed your plea bargain agreement. If they were to say, I want you to have 3 years in prison, and that's your agreement, and then I were to come back and say, I'm not giving you 3 years in prison, I'm accepting your plea and I'm giving you 4, or I'm giving you more than that, I'm not allowed to do that because that's not a part of your plea bargain agreement. The length of time someone is on probation, that's for the court to decide. Whatever conditions, that's for the court to decide. For example, when you hear me telling people you're to report every month, if I were to tell probation they can report once every 6 months, then those are my conditions. And they only have to report once every 6 months. Do you understand?
Yes, ma'am.
So the state and the defense are telling me that they want you to have 2 years probation, the length of time. They can argue for that, but I don't have to give you 2 years. I can look at it. Maybe I will give 2 years. I don't know. I don't know anything about this case. I don't know the facts of the case. I could give you 3 years. I could give you 4 years. I could give you up to 10 years probation. I don't know because I don't know anything about your case. But they can argue and say they want you to only have 2 years deferred. Do you understand?
Yeah.
All right. So if y'all want to step back and discuss that, you can step back to discuss it. If you still want to go forward with your plea bargain agreement, then this for a period of 2 years, that's initial. need to be removed from above the line.
Judge, we can scratch it out, Judge.
All right, so if you all want to. All right, we're back on the record. So with regards to the plea bargain agreement, is there any objection from the state or the defense, thank you, to the court removing the words "for a period of 2 years" next to "the state recommends deferred adjudication"?
We do not, Judge.
All right, so the court will remove that portion. And Mr. Arriaga, do you have any objection to the court removing that?
No, I don't.
All right. So you understand the range of punishment?
I do.
And you understand that if you have a plea bargain agreement, the court does not have to follow your plea.
I do.
If the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Do you understand?
Yes, ma'am.
The lesser included offense, how do you plead? Guilty, not guilty, or no contest?
No contest.
State any evidence.
Yes, Your Honor, this time state offer 6 Exhibit 1 with all attachments.
No objection, Judge.
All right, and state, have you spoken to the complainant or the complainant's family?
We have, Your Honor.
All right, thank you. You may be excused.
Your Honor.
Did you review the waiver and consent to stipulations of testimony and stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
I did.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent?
Yes, ma'am.
Did you understand that today the state would be presenting evidence in the form of witnesses' statements and police reports? But most importantly, there'll be no live testimony. Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments and review the same. All right, after reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty. The court will defer finding of guilt as you've applied for deferred adjudication. Are you proceeding with sentencing?
We'd like to, judges.
Anything you wish to say on behalf of your client?
Judge, all I can say is that, as you can see from the nature of the plea bargain, there was a lot of exchanging between the parties of information, mitigation, the history of the case, the issues with the child. Unfortunately, she had a very difficult upbringing, losing a parent very young and didn't have the other parent. It just goes on and on. We went through CPS records, we went through counseling records, and it was a hard decision for Mr. Arriaga to arrive at, but he felt it was in the best interest of himself that he not expose himself to a different kind of an outcome. And he's going to have an extensive registration, which doesn't begin until after the term of probation expires, which is why we had such a long discussion about how long his probation was going to be for. He has a clean record for the most part. He's been gainfully employed. He's never missed court, never been late to court, has not had any violation reports. He's ready to put this case behind him. We do want to address one issue regarding his ability to have access to his grandchildren. Because of the nature of the case, obviously there are restrictions in that regard. The parent of those children is here in court. If the court needed to hear from him, or he could advise probation in writing what his desires are in that regard. He's not asking for unsupervised. He just wants to be able to see him as he has been their whole lives. Other than that, Judge, we ask the court to follow the plea agreement.
All right, this is what the court is going to do. Is there anything you wish to say?
No, ma'am.
All right, and what do you do for employment? Not where you work, but what do you do?
I'm a barber.
All right, this is what the court is going to do, is a $1,500 fine, time and money, $1,500 fine probated. Chapter 62 registration. There's to be no contact with the complainant. Regular reporting by Zoom or in person. Proof of employment within 30 days. No employment as a home health care provider or with minors. Regular and random UAs. With the UAs, you can either do a patch. The patch costs more, but you won't have to, it's less time constraints on you. There's to be no unsupervised contact with minors. If he's to have a contact with minor, it'll have to be an approved chaperone by probation. And usually, for example, with regards to your grandchildren, you'll need that person to be the supervised chaperone. Usually it's approved. If it's not approved or there's something with that, just let the court know.
Understood.
And he'll be with the sex offender unit, and the court is going to sentence you to 4 years deferred adjudication. Did you review the document entitled Trial Court Certification of Defendant's Rights to appeal with your attorney. Did you understand it and sign it? Thank you. Probation 2024 CR 012995, State versus D. Anthony Bernard Perkins. Could I have parties announced for the record for the state?
Megan Galloway for the state.
Defense?
Albert Chidas for Mr. Perkins.
And are you Mr. Perkins?
Your Honor.
Counsel, have you received all discovery? Did you review it with your client?
I have.
Court will find that the state is in compliance with discovery. Mr. Perkins, did you review the document entitled stating the evidence?
State offers states exhibit number 1 in attachment.
No objection, Your Honor.
All right, and state, have you reached out to the complainant?
Yes, Your Honor. They're satisfied with the agreement here.
All right, thank you. You may be excused. Did you review the waiver and consent to stipulation with the attorney? Did you understand it? And did you sign it in all the appropriate places?
Yes.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent? Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand? Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments and review the same. All right, after reviewing states exhibits 1 and attachments, the court will find there's sufficient evidence to find you guilty, and the court will find you guilty. Are you proceeding with sentencing?
Yes, Your Honor.
Is there anything you wish to say on behalf of your client?
No, Your Honor, we just want to proceed with the agreement. I think as a misdemeanor punishment on a state jail conviction, it's a judgment satisfied.
All right, the court is going to sentence you to 108 days in the Bexar County Jail under 1244. Give you credit for any time served. There's a $2,000 fine, time and money to run concurrent. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand? All right, we can go off the record. So now you have a felony conviction of a pair of shoes. I don't know why people think brand name shoes or a particular brand name shoe is worth potentially going to prison over having a felony conviction. So now, whenever you go somewhere for a place employment, guess what? It's going to pop up that you're a felon. You understand? Make better choices. Good luck to you.